Hello, my name is John Snow, and I'm an attorney with the law firm of Parsons, Bailey, and Latimer. We have offices in western states, and one of the things that I do for a living is construction litigation, and as a result, I do review a lot of construction contracts, and in connection with that, I do from time to time review contracts for clients concerning specific issues. And I don't draft per se because I litigate and therefore I leave real lawyering to others, but I do review contracts for purposes of issues. And in my experience, I have come across 12 or 13 fundamental issues that you encounter in a construction contract. And the purpose of this seminar is to give an overview of construction contracts and things to look for specifically, whether or not you're enforcing a contract through litigation or litigating a contract in some type of construction defect or for payment, whatever, or drafting. And we're going to just touch on some of the more frequent provisions so you understand how they work in relationship to one another and to some extent in the real world. One of the things that's true with every contract, and specifically true with construction contracts, is that the contract is all about risk shifting. It's deciding who is going to bear what risk regarding the construction project. For example, who is going to bear the risk of an injury to a third party on the construction site? Is it going to be the owner? Is it going to be the general contractor? Is it going to be a subcontractor? Is it going to be the vendor of machinery or materials that are going into the project? These kind of issues can be worked out before the project even starts. And as a result, you eliminate issues that could have been handled more easily if they had been addressed at the beginning of the project with a proper contract. You can see construction contracts that are hundreds of pages long, and they still will not be able to cover every single issue that may arise. There is always an ambiguity no matter how big the contract or how little. Now, of course, the bigger, the larger the contract, the more details that are covered, the less likelihood, the likelihood of confusion or ambiguity is less, of course, but nonetheless, it always exists. But going back to the purpose of a contract, it is to allocate risk, including risk of payment by the owner. And the owner doesn't pay the general, does the subcontractor to the vendors also assume some of that risk or not? It's all part of the contract. It's all part of risk shifting. And we're going to talk about a few issues in that regard. Now, the first issue that I look for in a construction contract is who is going to be bound by the contract. Now, you may say this is a no-brainer because it's the parties to the contract, but you would be surprised how many times people who are not a party to the contract will sue in tort. For example, a subcontractor who is delayed on the project because of the owner's design people having provided faulty plans. There's no privity of contract between the owner and a subcontractor, and therefore the subcontractor doesn't have a claim against the owner because there is no privity. Likewise, the economic loss rule can interfere with recovery on a negligence claim when there's a contract that's existing or covering the situation. So the idea here is when I talk about privity, I know who's the parties to the contract. For example, the general contract is going to be between the owner and the general contractor.